The Supreme Court chamber fell into complete silence as Associate Justice Amy Coney Barrett delivered the court's majority opinion in United States versus Amazon Technologies, Inc. Her voice, measured but resolute, carried throughout the ornate room as cameras captured the historic moment. In consideration of the unprecedented scale of data privacy violations and the deliberate circumvention of established regulatory frameworks, this court finds Amazon Technologies liable for statutory damages in the amount of $1 billion, Barrett stated, her tone leaving no room for ambiguity. The systematic collection and monetization of consumer data without meaningful consent constitutes a violation of federal privacy statutes at a scale previously unseen in American jurisprudence. The gallery erupted in hushed murmurs as legal observers exchanged shocked glances. Not since the antitrust cases of the early digital era had the court levied such a significant penalty against a tech giant. Attorneys for the Department of Justice could barely contain their surprise at the scope of the victory, while Amazon's legal team huddled in visible distress. What no one in that chamber could have anticipated was what would happen next. Within 48 hours, Jeff Bezos, the founder and executive chairman of Amazon, would make a move so unexpected and strategically brilliant that it would not only neutralize the court's billion-dollar penalty, but fundamentally transform the relationship between America's highest judicial body and the tech industry for decades to come. The confrontation between one of the court's most respected legal minds and one of the world's most powerful businessmen was about to take a turn that would leave the entire nation speechless. Before we dive deeper into this extraordinary legal clash, make sure to hit that subscribe button and turn on notifications so you won't miss our next analysis of the pivotal moments reshaping America's legal and business landscape. Associate Justice Amy Coney Barrett had established herself as one of the court's most methodical and principled jurists since her controversial confirmation in 2020. At 52, the former Notre Dame law professor had confounded early critics who had predicted she would be a reliably partisan vote. Instead, Barrett had carved out a judicial identity marked by careful textualist analysis that occasionally led her to break with ideological expectations. The Amazon case represented a culmination of Barrett's evolving jurisprudence on digital privacy. As technology had radically transformed daily life, Barrett had developed a sophisticated framework for applying constitutional principles to modern data issues. Her scholarly background had prepared her to grapple with the complex intersection of established legal doctrines and rapidly evolving technology. For Barrett, the stakes extended far beyond this single case. The court's credibility in the digital age depended on its ability to meaningfully check the power of tech giants whose influence often exceeded that of traditional government institutions. A failure to establish clear boundaries would render the judiciary increasingly irrelevant in regulating the most powerful forces shaping modern society. Jeff Bezos, 60, had built Amazon from an online bookstore into one of the most valuable companies in history. After stepping down as CEO in 2021, he had remained as executive chairman, focusing on strategic initiatives while pursuing his space exploration ambitions through Blue Origin. With an estimated net worth exceeding $140 billion, Bezos possessed resources that rivaled those of many nations. What made Bezos particularly formidable wasn't just his wealth, but his legendary strategic thinking. Known for his day one philosophy that emphasized constant innovation and customer obsession, Bezos had repeatedly demonstrated an uncanny ability to transform apparent setbacks into opportunities for growth and market dominance. For Amazon, the billion-dollar fine, while significant, represented less than 1% of the company's annual revenue. The real threat lay in the precedent it would establish. If the Supreme Court's interpretation of privacy statutes stood, it would fundamentally alter Amazon's data-driven business model and potentially inspire similar litigation against all major tech platforms. The legal community had expected Amazon to pursue traditional appeals, or to lobby Congress for legislative relief. No one anticipated that Bezos himself would intervene with a strategy that would challenge not just the fine, but the very framework of how America's judicial system interacted with the tech industry. As legal experts across the country dissected Barrett's 57-page opinion, Bezos convened an extraordinary meeting at Amazon's Seattle headquarters. Present were not just the company's top attorneys, but also leading scholars in constitutional law, data ethics, and regulatory policy. An unusual assemblage that hinted at the unconventional response being formulated. Justice Barrett's opinion reflects a fundamental misunderstanding of modern data architecture, Bezos reportedly told the gathered experts. But it also presents an opportunity to reshape the conversation entirely. Within 24 hours of the court's ruling, as media coverage focused on the historic fine, Bezos's team was already executing a multi-pronged strategy that would soon leave both supporters and critics of the court's decision utterly stunned. Justice Barrett's opinion had methodically dismantled Amazon's legal defense, citing internal documents that revealed systematic efforts to collect user data beyond what was disclosed in the company's privacy policies. The opinion was particularly scathing in addressing what Barrett called notice theater, the practice of burying critical privacy information in lengthy terms of service that no reasonable consumer could be expected to comprehend. The defendants claim that consumers provided informed consent cannot be reconciled with the deliberate complexity of their disclosure mechanisms, Barrett wrote. Constitutional freedoms lose their substance when meaningful choice is rendered impossible through deliberate obfuscation. The opinion had garnered support from an unusual coalition of justices, with both liberal members like Sotomayor and conservatives like Gorsuch joining Barrett's textualist approach to statutory interpretation. Only Thomas and Alito had dissented, arguing that the court was overstepping its role in what should be a legislative matter. As legal analysts debated the long-term implications of the ruling, Amazon's official response had been surprisingly muted, a brief statement expressing disappointment and noting that the company was evaluating all options. This uncharacteristic restraint should have been the first clue that something unprecedented was in development. 48 hours after the court's ruling, Jeff Bezos published an open letter that would appear simultaneously on Amazon's website, as a full-page advertisement in major newspapers, and as sponsored content across digital platforms. The letter began not with the expected legal objections, but with a stunning concession. Justice Barrett's analysis of current privacy practices is substantively correct, Bezos wrote, immediately capturing national attention with his unexpected acknowledgement. The ecosystem of data collection that has evolved in the digital age has indeed outpaced both regulatory frameworks and consumer understanding. Rather than contesting the court's findings, Bezos pivoted to a proposal that would reshape the entire conversation. Today, Amazon is not merely accepting the court's penalty. We are transcending it. I am announcing the creation of the Digital Rights Foundation, independently endowed with $5 billion, 5 times the court's mandated penalty, to establish a new framework for data rights in the digital age. The announcement sent shockwaves through legal, tech, and financial circles. Amazon stock, which had dropped after the court's ruling, surged on the news as investors recognized the strategic brilliance of Bezos's move. By vastly exceeding the court's penalty through voluntary action, he had seized control of the narrative while positioning Amazon as a leader rather than a defendant. But the most groundbreaking aspect of Bezos's announcement was still to come. I am extending a formal invitation to Justice Barrett to serve as the honorary chairperson of the Foundation's Judicial Advisory Board upon her retirement from the court, Bezos continued. Her intellectual rigor and commitment to first principles make her uniquely qualified to help establish a framework that protects fundamental rights while enabling beneficial innovation. The invitation, which everyone understood Barrett could not accept while serving on the court, was a masterstroke of strategic positioning. It implicitly reframed Barrett from Amazon's adversary to a potential ally in solving the larger societal challenge. It acknowledged her expertise while subtly suggesting that true solutions would come not through punitive court rulings, but through collaborative innovation. Within hours, the White House, congressional leaders, and consumer advocacy groups were scrambling to respond to Bezos's unexpected gambit. The Justice Department, which had celebrated the court's ruling as a landmark victory, now faced the possibility that Amazon would emerge from the case with enhanced public standing and increased influence over the very privacy frameworks meant to regulate it. Justice Barrett, bound by judicial ethics from commenting on matters before the court or engaging with litigants, maintained a dignified silence. But sources close to the court reported that Barrett was deeply concerned by what some viewed as an attempt to co-opt judicial authority through private sector initiatives. As the public and media digested Bezos's announcement, a second phase of Amazon's strategy unfolded. The company filed a formal motion with the court, not contesting the billion-dollar judgment, but requesting a modification of the remedy structure. Rather than paying the fine directly to the Treasury, Amazon proposed creating a court-supervised restitution fund that would directly compensate affected consumers while funding research on privacy-protecting technologies. This procedural move was brilliantly calculated. It forced the court to either deny consumers direct compensation, appearing to prioritize government revenue over actual victims, or engage with Amazon's alternative framework, lending legitimacy to Bezos's approach. Either outcome would strengthen Amazon's position while complicating Barrett's clear moral high ground. As legal observers debated whether Bezos had outmaneuvered the court or merely exacerbated his company's legal jeopardy, the stage was set for an unprecedented collision between judicial authority and corporate power. The next move would belong to Justice Barrett and her colleagues, and their response would determine whether the court could maintain its authority in the face of Bezos's audacious strategy. 3 weeks after Bezos's announcement, the Supreme Court issued an unusual supplemental order in the Amazon case. Authored by Justice Barrett, the 5-page document addressed not just Amazon's motion, but the broader implications of Bezos's public campaign. This court acknowledges the defendant's right to engage in public advocacy regarding matters of law and policy, Barrett wrote in characteristically precise language. However, attempts to recharacterize judicial remedies as optional guidelines from which private entities may substitute their preferred alternatives fundamentally misunderstands the nature of judicial authority under Article 3 of the Constitution. The supplemental order firmly rejected Amazon's motion to restructure the penalty, noting that the company's proposed alternative impermissibly seeks to transform a judicial remedy into a private governance mechanism beyond the review of this court. Barrett's opinion made clear that the court would not be outmaneuvered by even the most sophisticated public relations strategy. Most significantly, Barrett directly addressed Bezos's invitation for her future involvement with his foundation. The independence of the judiciary requires not merely freedom from actual conflicts, but from the appearance of entanglement with litigants. Members of this court cannot and will not be enlisted, even prospectively, in private regulatory schemes established by entities subject to our jurisdiction. The forceful response reasserted the court's authority while exposing the strategic nature of Bezos's maneuver. Legal scholars immediately recognized the historical significance of Barrett's supplemental order, with one constitutional law professor describing it as the judicial equivalent of calling a bluff in high-stakes poker. What happened next demonstrated why Bezos had become one of the world's most successful business leaders. Rather than treating Barrett's rebuke as a setback, he executed a pivot so nimble that it transformed a potential humiliation into yet another opportunity. In a television interview conducted just hours after the court's supplemental order, Bezos appeared thoughtful and reflective rather than defensive. Justice Barrett is absolutely right about the separation of powers. he acknowledged with apparent sincerity. "My invitation was well-intentioned but inappropriate, and I thank her for the clarity of her response." Then came the unexpected turn. What the court's supplemental order makes clear is that neither government nor private industry can solve these challenges alone. We need a new framework that respects judicial authority while creating space for responsible innovation. Bezos announced that Amazon would not only pay the billion-dollar fine in full and without further appeal, but would also proceed with the creation of the Digital Rights Foundation, now restructured as an independent trust with governance shared between consumer advocates, academic experts, and industry representatives, with explicit provisions preventing Amazon from exercising controlling influence. The foundation will conduct its work with full respect for the judiciary's role, Bezos explained, while focusing on areas where private innovation and self-regulation can complement rather than substitute for legal remedies. This deft repositioning allowed Bezos to maintain the positive aspects of his initiative while gracefully retreating from the elements Barrett had identified as challenging judicial authority. The move was so skillfully executed that many observers failed to recognize that Amazon's fundamental business objectives remained protected despite the apparent concession. What followed was a masterclass in converting adversarial relationships into collaborative ones. Amazon announced a series of privacy-enhancing technologies that would give consumers unprecedented control over their data, while still enabling the personalized services that drove the company's business model. These innovations allowed Amazon to comply with the letter of Barrett's ruling while preserving the most valuable aspects of its data ecosystem. The company also initiated a privacy policy overhaul that replaced incomprehensible legalese with clear, graduated choices presented to users at relevant moments, an approach that actually increased customer engagement with Amazon services while technically reducing the company's legal exposure. In effect, Bezos had transformed a billion-dollar penalty and a judicial rebuke into a strategic repositioning that enhanced Amazon's market position, improved its regulatory standing, and established the company as a thought leader in digital rights, all while appearing to graciously accept the court's authority. The business world was stunned by the strategic sophistication of Bezos's response. He turned what should have been Amazon's darkest hour into a showcase for why he's considered the most formidable business strategist of the digital age, wrote one business analyst. While fully complying with the court's ruling, he's managed to strengthen Amazon's long-term position. For Justice Barrett, the resolution represented a more complex victory. The court's authority had been maintained, and the substance of her privacy jurisprudence remained intact. Yet Bezos had succeeded in shifting the implementation of those principles from a purely punitive framework to one that potentially advanced Amazon's business interests while addressing the underlying concerns. As the dust settled, observers from across the political spectrum recognized that they had witnessed not merely a legal confrontation, but a historic negotiation between two of the most significant power centers in modern America, the Supreme Court and the tech industry, with Barrett and Bezos serving as their respective champions. The Barrett-Bezos confrontation quickly transcended the specific facts of the Amazon case to become a defining moment in the evolving relationship between America's traditional governance institutions and the digital platforms increasingly central to economic and social life. Legal scholars began referring to the Barrett doctrine of digital privacy, citing her majority opinion as establishing several crucial principles. That meaningful consent required actual understanding rather than formal acceptance of terms. That the scale of data collection could transform the nature of privacy violations from individual to systemic harms, and that courts could and should impose remedies proportional to a company's global operations rather than limiting penalties to what might deter smaller entities. At the same time, business schools developed case studies on what became known as the Bezos pivot, the strategic art of accepting adverse judgments while reconfiguring them into competitive advantages. Amazon's response became a template for corporate resilience, demonstrating how regulatory challenges could become catalysts for innovation rather than merely compliance costs. The Digital Rights Foundation, despite its controversial origins, evolved into a genuinely independent institution that helped develop privacy standards subsequently adopted by international regulatory bodies. The Foundation's work on graduated consent, presenting privacy choices in digestible increments rather than all-or-nothing agreements, became particularly influential, establishing a model that balanced commercial interests with meaningful consumer autonomy. For Barrett, the Amazon case cemented her reputation as a justice capable of applying traditional legal principles to novel technological challenges. Her approach attracted surprising support from both liberal consumer advocates, who appreciated her protection of individual privacy, and conservative jurists, who respected her textualist methodology and restraint in crafting remedies. In academic circles, the Barrett-Bezos confrontation sparked renewed interest in how governance functions when private entities rival or exceed the practical power of government institutions. The case became a staple in both law school curricula and business ethics programs, examined from multiple perspectives as either a triumph of judicial authority or a masterclass in corporate adaptation, or sometimes both simultaneously. Perhaps, most significantly, the confrontation established a new model for how conflicts between technology platforms and traditional governance institutions might be productively resolved. Rather than the winner-takes-all approach that had characterized earlier regulatory battles, the Amazon case demonstrated the potential for substantive accountability that nevertheless created space for continuing innovation. 3 years after the original ruling, Justice Barrett addressed the case publicly for the first time in an academic lecture on technology and the Constitution. Without discussing specific litigants, she articulated a vision of judicial engagement, with technological change that acknowledged both the necessity of applying enduring principles and the challenge of doing so in contexts the law's framers could never have anticipated. The Constitution's enduring genius, Barrett noted, lies not in predicting every circumstance to which it might apply, but in establishing principles flexible enough to protect fundamental rights across technological epochs while permitting society to enjoy the benefits of innovation. Bezos, meanwhile, incorporated lessons from the confrontation into Amazon's long-term governance strategy. The company established an internal constitutional framework that anticipated regulatory concerns rather than merely responding to them, embedding privacy and transparency principles into product development processes from their inception rather than as afterthoughts. In perhaps the most remarkable development, elements of Barrett's judicial reasoning and Bezos's implementation approach were eventually synthesized into federal privacy legislation that established clear boundaries while creating space for responsible innovation. The bill, passed with rare bipartisan support, demonstrated how adversarial encounters between institutions could ultimately yield constructive governance frameworks. For ordinary Americans, the most tangible outcome was a digital environment that increasingly respected their privacy choices while preserving the conveniences of personalized services. The informed consent mechanisms pioneered by Amazon in response to Barrett's ruling became industry standards, giving consumers meaningful control without requiring technical expertise. As new technologies from artificial intelligence to augmented reality presented fresh governance challenges, the Barrett-Bezos confrontation provided a valuable precedent for how America's legal and entrepreneurial traditions could engage in productive tension rather than irreconcilable conflict. Neither judicial authority nor technological innovation had been sacrificed. Instead, each had been strengthened through their engagement with the other. The lesson that emerged transcended the specific personalities and technologies involved. In a functional democracy, even the most powerful institutions must ultimately engage in a process of mutual accommodation, not by compromising fundamental principles, but by recognizing that their long-term objectives might be better served through adaptation than through unyielding confrontation. For a nation navigating the unprecedented challenges of the digital age, this lesson would prove invaluable in the decades to come. If you found this analysis of the historic Barrett-Bezos confrontation insightful, please like and subscribe to our channel for more in-depth coverage of the pivotal legal and business developments shaping America's future. Share your thoughts in the comments. Do you believe the balance of power between the judiciary and tech giants has been permanently altered by this case? Your engagement helps us continue bringing you thoughtful analysis of today's most consequential stories.